Uh, Good evening. Master Treasurer, Masters of the Bench, ladies, gentlemen, non-binary and gender fluid friends. Welcome to this, the inaugural public lecture of the LGBTQ plus society at Inner Temple. My name is Dr. S. Chelvan. My firm pronouns are he and him. And on behalf of the society, I welcome you to this lecture by Master Kirby, whose tonight's lecture is entitled Sodomy Law, the UK's Persisting Legacy, the Great Quandary. Before I introduce our speaker for tonight, some housekeeping rules. Can I first of all say, for any students who are registered on the qualifying session, you must sign the register outside this lecture room at the end of the evening to be able to register your attendance. Secondly, we have quite a few people who have attended online. There will be a question and answer opportunity at the end of Master Kirby's lecture. For those people who are online, please feel free to register your questions through the question and answer portal on your screen. Now, Master Kirby, for most of us, will not need much of an introduction. I know when I attended my first ever lecture where he provided a wonderful speech about the Commonwealth in 2008, I was so inspired that I decided to start a PhD. So I'm slightly worried about what I'll do after tonight's lecture. But as I said, Master Kirby for us here at Inner Temple, because he was elected a bencher here at Inner Temple in 2006. But for those who need more of details of his bio, he was a High Court of Australia judge until the 2nd of February 2009, having previously been a judge of the Federal Court of Australia and president of the Court of Appeal of Solomon Islands and president of the New South Wales Court of Appeal. He's also served on 3 university bodies and served on many national and international bodies, including being president of the International Commission of Jurists in Geneva and UN Special Representative for Human Rights in Cambodia. Following judicial retirement, Master Kirby was elected president of the Institute of Arbitrators and Mediators in Australia. He's been appointed an honorary visiting professor by 12 universities, and he also serves as editor-in-chief of the Laws of Australia since 2009. Various international bodies, including being commissioner of the UNDP Global Commission of HIV in the Law in 2011 to 2012. In 2013 to 14, he's appointed chair of the UN Commission of Inquiry on Human Rights Violations in North Korea, and was also sat as a commissioner of the UN AIDS Lancet Commission on AIDS and the Right to Health. He was awarded the Australian Human Rights Medal in 1991, and in 1997, in May, he was invested by Japan as the insignia of the Order of the Rising Sun, Gold and Silver Star in Tokyo, with an audience with the Emperor of Japan. He was also named in 2018 the United Nations Honour by the United Nations Association of Australia. So with not much further ado, ladies and gentlemen, Master Kirby.
Thank you very much, Dr. Chelvan, for that introduction and for all the work that you and Jenny Collis-Price and other officers of Inner Temple have done to make this a success tonight. I hope I'm not going to muck it up. It's very good to see so many people here. I'm very proud to be inaugurating this lecture series, and I hope it goes on from strength to strength. I honour the presence here of Sir Robert Francis, the Treasurer, and I can't tell you how proud I am to be an honorary bencher of Inner Temple. It's in a life in which I've had altogether too many honours and privileges. I am especially proud of this because it establishes for me a link with the legal system, which is so precious to me and to the world. And if tonight I say a few nasty things about that legal tradition, then that's par for the course. Today in New Delhi, at the grand building which is the Supreme Court of India. The argument began in a case which is designed to bring that court under a very great Chief Justice Chandrachud, son of a Chief Justice of India, and a man of great erudition, to apply the principles in the case today on marriage equality, which he and four colleagues in a unanimous five-judge bench in 2019 proclaimed as invalidating the law which had been imposed in India in 1870 under the Great Indian Penal Code, one of the many great gifts of codes which the British administration gave to India. Section 377 was that template provision which provided for criminal penalties on same-sex sexual activity. And the Supreme Court of India, led by Chief Justice Chandrachud, invalidated that section and read it down so that it applied only in very limited circumstances, and that doing that, they invoked the provisions of the Indian Constitution guaranteeing equality, guaranteeing dignity, and guaranteeing privacy. So those provisions were invoked there, and the question will be, do they extend that very important law, which immediately lifted the criminality on hundreds of thousands, if not millions, of Indian citizens and others in India that they had suffered since 1870 with the Indian Penal Code. And now, what I'm going to do in this lecture will be divided into three parts, like Caesar's Gaul. And the first part will be an explanation of how we came to the position that we are in the English law, and how that affected countries all around the world. The second part of my lecture will be to explain the steps and how it came about that body of law in so many Commonwealth countries, formerly parts of the British Empire, how that law was challenged and how a remarkable series of decisions of courts and also decisions of legislatures have overturned that provision. But still today, in the Commonwealth of Nations, of 56 member countries, 32 of them have criminal laws against same-sex sexual activity. And finally, I'm going to tell you of the work that I did, along with others, in an eminent persons group on the future of the Commonwealth of Nations. And that eminent persons group did many things, and we had a wonderful and very energetic member, Sir Malcolm Rifkind, who wasn't to be messed with. He was a past British Foreign Secretary and also Secretary of Defence. He and I took part a week or so ago, in March actually, in celebrating Commonwealth Day, and that highlighted the difficulties which the Commonwealth of Nations has if it's to survive, but also the imperative of giving effect to a charter which I claim to have been the principal drafter of, which included provisions relating to equality, human dignity, and privacy. So that's what I'm going to talk about, and I'm going to do so in the 40 minutes that have been allocated to me. How did we get where we are? Well, it came about, of course, from the Bible. And in the first two books of the Bible, Genesis and Leviticus, there are provisions which a human mind and a human hand once put down, probably on a piece of papyrus that had been brought up from the banks of the Nile, and which declared if a man sleeps with a man as a man sleeps with a woman, then he is committing an abomination, and surely he shall be put to death, and his blood is on the people. And that has been the source of the criminal laws and of the difficulty to change those laws, because if a rule is laid down by the Almighty, first in the words of the Almighty in Genesis, in the story of Sodom, and secondly in the holiness code of Leviticus, then it has to be taken seriously. And this is the source of the criminal laws that were adopted in many countries, and in England, in early passages in laws of England, explaining the common law of England, and in an early statute of King Edward I, creating the law of Sodomy. That law remained in force and was enforced by the church courts up till the reign of King Henry VIII, who, seeing an opportunity to enhance his power and his treasury, decided that he would sever the links of England and England's church with Rome. There was also the small matter of his marriage to Mistress Anne Boleyn, and that led to the sodomy law passing from the church into the hands of the king and the law of England to be enforced in the royal courts. That was in turn abolished by Mary, Henry's daughter, Queen Mary I, but it was restored by Queen Elizabeth I, and Mary had abolished it, not because she disapproved of such a law, but because she wanted to restore the church authority over such matters. Blackstone, in his writings in the 1760s, declared this as part of the law, and that it had always been part of the law, and he was unquestioning about it. In 1793, by way of contrast, in France, the Estates General, in the early days of the French Revolution, took a look at the equivalent part of the royal French law and said, this is nonsense, and it was abolished in France. A tremendously important development, because the French code, penal code, which was developed by Napoleon, but drawing upon the previous law, it did not contain a criminal offence. And all the territories that were ruled by France did not inherit a penal offence. Likewise, the laws of Germany, which copied the French penal code, likewise the laws of Russia, likewise the laws of China and Japan, and all the countries that had in the civil law tradition, they just didn't pick up the sodomy law. But everywhere where the Union flag ever flew, there was a criminal provision against same-sex activity by men, subsequently extended by statute in many countries to same-sex activity of women. In 1870, the colonizers were busy at work providing criminal codes throughout the British Empire. And those codes always contained provisions for a sodomy offence. The Indian Penal Code, as I've said before, was enacted by the Governor-General's Council in India in 1870. There were three template examples of a penal code on offer. One had been drafted by James Fitzjames Stephen. Another was written in the first instance for the Governor-General's Council in India by Macaulay, and a third was drafted by an Australian, Sir Samuel Griffith, who was the first Chief Justice of the High Court of Australia. And that his effort has been copied in many places in Africa, but most of the codes elsewhere are modelled on the Macaulay Code. And that influenced jurisdictions of the British Empire that didn't adopt codification. And in my own jurisdiction in Australia, New South Wales, the Crimes Act of 1900, which was in the last year of the reign of Queen Victoria, had a provision which was equivalent and in very substantial terms the same language as the exported provision throughout the empire. This was something you couldn't escape if you were part of the British Empire, whether or not it was part of the preceding law or part of the culture or even part of the religion of the country didn't seem to matter. It was imposed as part of the package that you got with many good things of the empire, uncorrupted judges and the rule of law generally. That was what happened everywhere. The idea of such a crime was questioned by Jeremy Bentham. He was very discreet about the way he questioned it. He didn't go into too many details, but he laid a question and unfortunately his question was not answered for a century and a half when later the legislators looked to this. Meanwhile, in the late part of the 19th century and the first half of the 20th century, a number of scientists began to look at the issue of what is the cause of people's different sexual orientation and also how many people are caught up in it. And Havelock Ellis, Kraft Ebing in Germany, Sigmund Freud in Vienna, Magnus Hirschfeld in Berlin, and in my life, the most important of the scientists who worked on this was Alfred Kinsey. I remember vividly learning at about the age of 9 or 10, which was a very critical age for such a discovery, the writings of Dr. Kinsey. Strangely enough, he was a very interesting man who had been the professor of zoology at Indiana University, and his expertise was in wasps, gall wasps. And he had millions of samples of gall wasps. but suddenly he got bored with gauntness. Can you believe it? And he turned instead to human beings and human sexual behaviour. And it's amazing, really, isn't it, when you look back on it? But it took all that time with Dr. Kinsey's research. His first book was on the sexual behaviour of the human male, and that was in 1947. And the other was on the human female, and that was in 1953. And he and his collaborators, especially Evelyn Hooker, extended the knowledge, and there may have been some faults in the methodology, but these were early days of taxonomy of human sexual behaviour. But the main message was clear. There are a lot of people, including many people whose basic and primary sexual orientation is heterosexual, who have at some stage in their lives a same-sex sexual attraction and activity. And growing up in the leafy suburb of Sydney, where I grew up, and under the pressure, which was very evident to me, even at the age of 9, that this was something that I was to be thoroughly ashamed of, was never to mention even to my parents or to my grandmother or to my siblings. This was a deeply shameful thing that you had to keep to yourself, and there was a deal. And the deal was, if you keep it to yourself and don't make us reflect in our minds upon the awful reality that there is not a binary division between human beings, we'll leave you alone. That was the situation in Australia when I was growing up. And that was the situation when I was first introduced to the criminal law on this subject, when I was taught the Crimes Act 1900 of New South Wales. And when I can remember it very clearly, I can remember the very time of that lecture. It was given by Vernon Triet, QC, who was a part-time professor, and he gave the criminal law instruction. And I remember feeling the blood rushing up to my head and feeling that this is terrible. I hope nobody knows that this is a provision that applies to me personally. And anybody who has had the experience of growing up in a country of British Dominion where there were the criminal laws of one of the 3 codes on offer will have had similar experiences. No doubt many in this audience have had a similar experience. The Americans, who are very prideful about their importance in the world, that it all started to change with Stonewall. Well, I have to tell you, it didn't all start to change with Stonewall. It started to change with a commission of inquiry by Sir John Wolfenden in 1957. Stonewall was in 1969. And in 1967, that's to say 2 years before Stonewall, I don't wish to appear to be bitter about this, but the English Parliament, just down the road, enacted the Sexual Offences Act, which applied to England and Wales, and it began the process of reform. It didn't immediately cover all same-sex activity. It didn't, for example, include those serving in the Defence Forces, and it didn't include multiple sexual activity, and it didn't apply to anybody under the age of 21, but the beginning was there, and that was a great achievement of law reform in the English-speaking people, and it was a much more significant achievement than Stonewall. Though Stonewall was important because it was an incident in the United States where people stood up and started to protest about it and started to question very publicly these laws, and therefore they deserve credit for that. Now, that's the first part. The second part is, how do we get ourselves out of this mess? The criminal law changed, as I've said, in England in 1967, and in 1970 and nearly 1980, I think it was, it changed in Canada and New Zealand. In Australia, it was very common in those days for us simply to look over to Mother England and to copy everything that she did. And it took an awful long time in Australia, where criminal law is the responsibility of the federal parliament mostly, to change the provisions of the Crimes Acts and criminal codes that imposed criminal penalties on gay people. 1973 in South Australia was the first step, and it came to an end in 1997 with the passage of legislation in Tasmania. But it was fought very bitterly all the way. In 1989, the parliaments of Queensland and Western Australia, both code states, changed their criminal codes, but they felt it necessary to have a preamble to the statute which said something words to this effect: the parliament of this jurisdiction doesn't really approve of what it's doing here. And it's very embarrassing to have to do it, but it has been advised that in order to combat successfully the HIV/AIDS pandemic, that we have to do this, and we just don't like doing it, but we're going to do it anyway. So that was how things happened. In the early 1990s, I was serving as president of the Court of Appeal of New South Wales, and I was telephoned by a couple whom I had met earlier, Rodney Croom and Nick Toonan. They were in Tasmania, and they rang me in my chambers because I was quite friendly with them, and I admired Rodney Croom, whom I knew well. And they said, we're thinking of taking Australia to the Human Rights Committee of the United Nations. That's a committee that's set up under the International Covenant on Civil and Political Rights, and it's based in Geneva and New York. And we're thinking of challenging Australia in respect of Tasmania, because this is the only jurisdiction now that still has this law. And we want to say that this is not compatible with Australia's ratification of the International Covenant on Civil and Political Rights, and not compatible with the provision of the first optional protocol giving Australians a right to complain to the Human Rights Committee. And they said, we want to know two things. First, will you give us some money in order to help us with this endeavour? We're not asking much, just a little. And second, would you give us some advice on whether this is something we should do? Now, this was not a matter that could ever possibly, in my wildest dreams, come before me judicially. And I therefore thought, well, I can give you advice. And I said, don't do it. Don't do it, because there's a principle in international law that unless you can show, it's like a standing principle, unless you can show that you are yourself really affected by a matter, international courts and tribunals will not touch it, because they'll leave it till a ripe time when it's available. And they said, thank you. I offered to send them, and I did send them a little bit of money, not very much. And they said, "Thank you very much, Justice Kirby, thank you." And put down the phone, and they immediately went and sent by fax their complaint to the Human Rights Commission in Geneva. The moral of that story is one that is relevant to this temple, and it's one relevant to all lawyers and lawyers in training. Courage, very important. Courage, very important in judges. And it's very important to seize the opportunity in the moment and not to put it off if there's a chance that the matter can be dealt with with greater justice. And so that's what they did. Years later, when I was elevated to the High Court of Australia, in the first week I was in the High Court of Australia, the registrar said, "We have a case that is coming up, and the case is Toonan against Tasmania." This was a case challenging the constitutional validity of a provision of the statute which was enacted by the Keating government in the federal parliament to override the Tasmanian law as being not compatible with the International Covenant on Civil Rights, which the Commonwealth had ratified. And so I said to the registrar, "Well, I'm afraid I can't sit in that. I've had connection in the past with the appellants because they wanted to assert that they had standing to challenge the Tasmanian law, rather to challenge the Tasmanian challenge to the federal law that was seeking to override the Tasmanian law." And the media were all in a great fuss about this. They wanted to know why Justice Kirby would not be sitting with his well-known liberal views. He would not be sitting in this matter. And I said, "I've had connection with these litigants in the past. I even have given them money for litigation. And so I can't sit." Now, there's a principle in the Australian Constitutional Court that you've got to have a very, very powerful reason for not sitting. But that's another principle of our system, and it's a good principle. You don't get involved if you have had any connection, any serious connection with the party. Maybe that is a bit of news that might be shared with Justice Thomas. Anyway, that's the only indiscretion that I will utter today. And so that began the step that ultimately the Tasmanian government gave in, and it repealed the law in the Tasmanian Parliament. And so from one side of the continent of Australia to the other, it no longer applied in Australia. But that left a lot of work to be done in the Commonwealth of Nations. In 1993, the Mandela government in South Africa introduced legislation to amend the South African criminal law, and it was supported by a lot of lawyers who had supported Mr. Mandela, who were gay. And that law, the challenge to that law was upheld. And so the position in South Africa was pulled into line. 2005 in Fiji, an Australian judge sitting in the Court of Appeal of Fiji held that the Fiji criminal law was unconstitutional, and he called in aid the then recent decisions of Dudgeon and Norris in Ireland. Then in 2015, Belize, the Supreme Court of Belize struck it down. In 2019, in the Supreme Court of India, struck down. In 2018, a number of Caribbean countries had challenges in their constitutional courts. 2020, Botswana struck down. 2022, Antigua and Barbuda struck down. 2022, St. Kitts and Nevis, likewise, and the same year in Barbados, the law was struck down. There were a few disappointments on the pathway to these decisions, including, I must say, with respect, as we have to say when something nasty is now going to be said, a series of 3 decisions of the Judicial Committee of the Privy Council in Bermuda, Cayman Islands, Trinidad and Tobago. There's been a lot of writing on those 3 decisions, and they contrast markedly with the decisions of the Caribbean Court of Justice. But in Uganda, we now have the new legislation, which is before the President for assent, which imposes the death penalty on certain conduct of LGBT sexuality. 2023, this year, Kenya, though not dealing with the criminal statute, which is still in force in Kenya, did make a decision in the highest court of Kenya that gave leave against government opposition to the registration of a political party that had gay law reform in its title. And that was upheld in Kenya as required by free speech under the Kenya Constitution. And last week, little Cook Islands, the Cook Islands, which are a dependency of New Zealand, decided that it would remove the provision in the criminal law of Cook Islands. But as I've said earlier, the situation remains that the majority of countries of the Commonwealth of Nations, 32 out of 56, have criminal provisions, and it's similar to a weed we have in Australia, which was imported unwisely from New Zealand, from South America rather, called lantana. And lantana is very hard to get rid of, and likewise have been the penal statutes of the Commonwealth countries against same-sex activities. Now, the third part of my address arises out of the work I did on the Eminent Persons Group. The Eminent Persons Group was designed to advise the members of the Commonwealth of Nations what should be done to liven up the Commonwealth of Nations and to make it more relevant to the problems of today. And I was appointed, I don't know what was behind that or how it happened, but I was appointed, and there were some very fine and able people on it. It was chaired by Tun Abdullah Badawi, who had been the Prime Minister of Malaysia. At our last meetings in Kuala Lumpur, in fact, with a meeting with the then Prime Minister of Malaysia, who is now in jail, but it wasn't a very friendly place for proposing changes that would be beneficial to LGBT people. But remembering what I'd done in the Tunen case, I went for it, and I said, we've got to have 2 things. First, we've got to have provisions for the better treatment of people with HIV and AIDS, because statistics that had been gathered by UNDP showed that in the Commonwealth Caribbean, the AIDS incidence was very high, whereas in the French countries of the Caribbean and the Spanish and other non-Commonwealth countries, they had had more success because they didn't criminalise the people who were most at risk. And secondly, we should have a charter of the Commonwealth. I didn't say this, but once you take away allegiance to the single monarch, which was the foundation of the British Empire, we all owed allegiance to the Crown. And you've got to find some better glue to bind the community together. And hence, I and the other members of the Eminent Persons Group agreed that we should have a charter. And that charter was agreed to, but everyone said, we just don't have time to draft it, we can't do this is complicated, we don't have time to approach the countries concerned. And I said, leave it to me. Well, I didn't actually say that. I didn't say anything. I simply got on my Qantas jet on the long journey home to Australia, and I kept calling for paper napkins from Qantas. And on the paper napkin, I wrote out the draft and the structure of the Charter of the Commonwealth. I've written essays since then comparing what finally emerged from the leaders and their officials, and it's basically the same. It's improved in many respects, and it's certainly improved by the endorsement of the officials, which then led to the Chogham meeting in Perth and subsequently giving approval to the new charter. It contains provisions guaranteeing equality, holding that the fundamental rights in the charter are universal, indivisible, and interdependent. And in the charter, it declares in several passages the vital importance of human dignity and says we are implacably opposed to discrimination of any kind. And of course, discrimination of any kind against people on the ground of race, gender, so-and-so, or other cause, similar to the Universal Declaration of Human Rights. That becomes the catch-all that carries those forms of discrimination that are similar or have a similar basis. The Charter of the Commonwealth, absent the paper napkins, was signed into force by Queen Elizabeth II at Marlborough House on the 11th of March 2013. And last month, on the 11th of March 2023, we had a big reunion. There tend to be these reunions, and it was a reunion which was celebrated by the new monarch as head of the Commonwealth. There was a service at Westminster Abbey where the Dean of Westminster Abbey said we must give effect to the Charter of the Commonwealth. The Secretary General of the Commonwealth, Baroness Scotland, said we must make this a solemn affirmation, and everyone in the Abbey stood, and in the presence of the King, the Queen, and members of the royal family, there was a solemn affirmation of the acceptance and importance of the Charter. King Charles III, in his first Commonwealth Day speech, said, these are not just words. We must ensure that they go beyond words and that they become action. These are not simply ideals, and we must show courage and restlessness, that was his word, restlessness about the provisions of the Charter. A very strong, wonderful statement by the King, which you've probably not heard of, but everyone who was in the Abbey that day. As well as that, he did something that his late mother dearly loved in many countries of the Commonwealth, never did. He held a big reception at Buckingham Palace, and that's where I went on the night of the reception on Commonwealth Day. And there was one very unique feature of the service that was held in Westminster Abbey. It finished with that marvellous hymn, crown him with many crowns. It's a very beautiful English language hymn, but it had been organised at the request of the king with singers and performers who were from different parts of the Commonwealth, from Africa. A group of performers came rushing into the Abbey, singing out in high tones and in angry voices. And similarly, there were people from Cyprus performing and others. This was a real Commonwealth flavour to the service in Westminster Abbey. And I don't know, but I wouldn't be surprised if John Elliott Gardner, who's going to give a performance of the coronation service, which is going to be a bit different this time, indicating, and I think that would be a good thing, indicating the change that has come on the Commonwealth. But the fact that 32 of 56 are still resistant to change, and the fact that it's extremely difficult to get them to even talk about it, this is the wicked problem of the Commonwealth now. How do you keep together a family of nations which could so easily dissipate, but stays together and has many very good things that it does together? How can you do that if you respect the right to differ, and especially on things that are religion or culture? How, if you say the feature of the Commonwealth is we respect each other and our different views, how can you do that when it comes into conflict with a fundamental principle that is expressed in UN human rights law and is also expressed in the Charter of the Commonwealth? This is a very large problem. Unless it can be solved within the Commonwealth of Nations, then the likelihood must be that the Commonwealth of Nations will not long continue. And that would be a tragedy for humanity. And I therefore hope that we can bend our minds to this problem and resolve it in a way that is both respectful of diversity, but as in domestic jurisdiction, where issues of fundamental human rights come forward, also respectful of the fundamental human rights of everybody, on the grounds of race, on the grounds of indigenous status, on the grounds of gender, and on the grounds of sexuality.
I'd like to thank Master Kirby for what was a tour de force for a lecture. Thank you so much. We've now got the opportunity for you to ask questions to Master Kirby. Can I also remind those who've joined us online, please use your question and answer function on your screen to be able to ask questions. We've already got one or two questions here. Can I invite any questions from the floor? And if you ask a question, if you can say your name as well, and Jenny will have the microphone. Sir.
Thank you very much, sir. My name is Sebastian Townsend Kagison. I'm a barrister and solicitor from of the Supreme Court of Nigeria, but I'll be practicing here in England and Wales, and regulated by Solicitors Regulation Authority, before now transferring as a qualified barrister through the Barrister Board. Now I have a question, and that's the reason why I was particularly interested in this. Your experience in the Commonwealth region, in which Nigeria is part of it. And we have a very complex legal system in Nigeria, because we have the criminal code in the south and the penal code in the north. And because the northern part of Nigeria is mostly predominantly Muslim, as you will understand, and we have Muslim radicals, it's been a very difficult thing in terms of respecting LGBT rights in Nigeria. And I'm just wondering if, you know, with your experience, if there are any form of advice or guidance as to how we can persuade the northern part, because it's mostly the northern part that not accepting, that these people have a right to be.
Well, this is the wicked problem. How do you get under the mindset of those who are opposed and say they are conforming to the rule of God? How do you find a way around that? And you're not going to find a way around it by hectoring people or attacking them. I went to a Commonwealth Law Conference in Glasgow, must have been about 10 years ago, and there was a huge delegation from Nigeria. And the delegation protested at my paper, which was saying some of the things that happened here. And they were not happy at all, and they were threatening to walk out. And I had a magic solution. I burst into the song, the old national anthem of Nigeria. Nigeria, we hail thee, our own dear native land. And they all fell into absolute silence. And they all stood up because it was their old anthem. I'd gone as a student at age 21, soon after independence of Nigeria. I went everywhere in Nigeria. I love Nigeria. I love Nigerian people. And I reached out on a human level to them. And it doesn't always work. Kano, for example, a northern state of Nigeria, has introduced the death penalty. It's one of very few. Pakistan, Brunei, Kano in Nigeria. But this is the wicked problem, and I don't quite know what the solution to it is, but it's not going to be by simply shouting at each other. It's going to be by showing empathy and respect. I once went to a law school in the capital, the new capital, Abuja, and I spoke about this, and then some of the lecturers said, "Oh, you can't speak about this subject," but the students all rushed up. They all wanted selfies. They all thought it was wonderful. They were new people of a new age. So I can only offer the suggestion: we mustn't hector. We must seek to understand. We must be respectful, but we must engage in dialogue, and it must be serious dialogue, and it mustn't just give in because it's difficult.
Gentleman over there in the second row.
Gabriel, I'm a student here in a temple. Thank you very much for that talk, which is highly informative. You have mentioned that there's the wicked problem of how we enforce the Charter. It seems you've also hinted there's a second problem, which is member states of the Commonwealth with a federal structure have a further potential area of entrenchment of homophobic laws at state level. Will the job be done if we can solve this first wicked problem, or will it just shift down to the federal state dispute level after that?
First of all, I don't like that expression, getting the job done. But that's a matter on which good people may differ. There was a very important provision in the Charter, as drafted by me and as adopted by the... we didn't actually adopt my draft, but we said this is a good starting point, and that led on to the officials, the Sir Humphreys of this world, and that led on to the Charter as it was ultimately made. And we suggested that there had to be an instrument, which we called the Commissioner, who would bring the matter to the attention of the country concerned and take other steps that we outlined in order to give effect to the Charter. The Secretary-General said that's not really necessary because the Secretary-General can do this. But the Secretary-General is like the Secretary-General of the United Nations. He's political. To do the enforcement and to do it subtly and with intelligence within the system which is political, but acting on principle, you need somebody who will do that job. And that was why we said you need a charter, and we still need a charter. And until we, a commissioner, until we get a commissioner, I'm not sure that it's going to be very successful. Baroness Scotland hasn't said very much about many of the problems that have arisen, or the issue of the 32 out of 56. And that's difficult for the political bureaucrat. But it's not all that difficult for a person who is a charter as their daily bread. And that's what I think we've got to do. And that was what all members of the Eminent Persons Group thought we should do. That's what we recommended.
Master Kirby, if I can ask a question as a refugee lawyer. At the moment, refugees and safe legal routes are a hot topic here in the UK. Taking consideration what we said about the UK's legacy to the Commonwealth, especially those 32 countries which still have colonial laws, do you think the UK should have an obligation to open safe legal routes to LGBTI refugees from the Commonwealth?
Well, first of all, there were many wonderful gifts, and I'd be the last person, having spent my whole life in expounding, interpreting, applying laws, which were many of them derived from England, many wonderful things, and it's part of a great legacy. And I think it's the knowing that legacy exists that has kept the Commonwealth together when it didn't have to, and it could have been wound up and a bit of money would have been saved, but it has kept going. People like to go to the Commonwealth meetings, but so far as the LGBT component in refugee law, we've had a number of those cases in the High Court of Australia, and in one of them the court was divided 4-3, and I was one of the majority, and that was a case from Bangladesh where the tribunal which decides these matters said that if this person was very quiet and didn't make any complaint and didn't assert that he was gay, in other words, stuck to the deal, he would be left alone. But he didn't want to do that. He had a partner and he didn't want to do that. He wanted to be himself. And 4 of us thought that if you apply the principle of the Act, the Migration Act 1958, and if you apply the lessons from Anne Frank, holed up in that little room, in the back room in the Prinsengracht in Amsterdam, and if you expect everybody to be an Anne Frank, then that is not what the Charter, what the Refugee Convention and Protocol are meant to do. And that was the view of the majority. The judge is in the minority, as always. I mean, there's always another point of view. You can write any decision, I can tell you, both ways. They said it's a factual matter. As a matter of fact, this is a person who in the past has kept quiet, and therefore, looking at the future, the tribunal came to the conclusion that if he was sent back, he would just go back to what he was doing. And that is the factual matter. And that was the view of the minority. So you'll understand that how important values are in judicial determining, how important it is to have values, how important it is to have sources of the values, such as the International Covenant on Civil Rights, the Universal Declaration, which we'll be celebrating 75 years of this year, and the Charter of the Commonwealth. These are the sources of courage and strength of the judiciary. With great respect, I think the decisions of the Privy Council, all of those were decisions on Caribbean courts where they themselves had found the courage to uphold in their own community the rights to marriage equality, as it turned out. And that was reversed in the Privy Council. I think it's such a contrast to the Caribbean Court of Justice. The Caribbean Court of Justice led by a wonderful judge, Judge Adrian, I don't remember his name. Yeah, a wonderful judge. And we need to cultivate more judges. And one way we can do that as LGBTIQ people and allies is to stand up and to express ourselves and to be truthful and honest and to say this is, as science is taught, this is not evil and wickedness. This is not an abomination. This is just part of the variation that is a feature of the human and other species. And get used to it. If you don't like it, you just got to get used to that fact. And Darwin actually, in his book The Origin of Species, said more important than the similarity of different generations are the differences. And I've often thought in my own case, with the great blessing of my partner Johan, who's in the Netherlands, and I'm going there next week, who's put up with me for 53 long years. I think it's really important to have a courage, and a courage based on science, and a courage based on honesty, on respect for people of different views, but ultimately insistence on the fundamental law of human rights. That's the great lesson of the Second World War. It's the great lesson of the law today. And I hope the United Kingdom doesn't tear up the Human Rights Act, because you have a job to be leaders in this matter. And that's something you must exert worldwide, but especially in the Commonwealth of Nations.
Moscow, you sort of answered one of the questions we've had online regarding the Privy Council cases, but one of the questions we've got online is, to what extent do you think political culture wars could lead to backward steps on LGBT rights?
Well, I mean, if there would be a country or countries with an alien or with an antagonistic political culture, they would be over there in the Caribbean. I know it because working for HIV with UNDP, I called many times on the Attorney General of Jamaica and said, this is something that is hindering your struggle against AIDS. It is something that is basically ignorant and unscientific. He was a very intelligent man. And he said, I know, but we'll lose the election if we do this. And this is part of the reality of politics. But that political culture of the Caribbean, as dealt with by Adrian Saunders and his colleagues in the Caribbean Court of Justice, the Privy Council was very important in the struggle against the death penalty in the Caribbean. But when it came to another group, it wasn't understanding. When I was young at law school, I never put up my hand and said, why do we not respect the rights of the indigenous people? Why do we not respect their right to land and their heritage? Why didn't we respect people of different colour? We were apartheid light. Why did we in white Australia have this system of law? And why are we continuing it when I was at law school? Why did we have these different laws restricting women and restricting their full equality? And I certainly never raised the question, why did we imprison LGBTIQ people? So we've got to ask questions, and we've got to be leaders in this struggle, because there are a lot of little people who can't be leaders, but everyone in this room today can be a leader. And in effect, you're being a leader by being here, whether you're LGBTIQ or an ally. It's a wonderful thing that you've come, and I hope there'll be more of it.
Well, if I can thank Master Kirby for his tour de force of a lecture this evening, those calls to arms in relation to asking questions, having courage. Sorry.
Would you repeat what you've just said?
Can I just thank Master Kirby for his the lecture, calling us
Tour de force, I think.
calling us to arms in relation to being leaders and having courage and representing those who are marginalized and vulnerable. It was a wonderful sort of inaugural lecture for the LGBTQ plus society in the Temple. Master Kirby, thank you so much for traveling halfway across the world and sharing your expertise and knowledge and views. There is a reception afterwards outside. Master Kirby will be there for a short period. Can I just take this opportunity to ask you all to join in my thanks to Master Kirby for showing his courage. Thank you.